Can I talk to you guys for a second? So, you know, if you're actually doing it for changing, I figured I'd let you guys know that.
Yeah. Okay, thank you. Because I guess it would.
Totally spaced over. I've already got it. Yeah. Thank you. See ya. Very much appreciated.
Right. Okay. Sure. Well, she wants to know, is it this part says it says that he's credited to the lead, and he doesn't work with that. So then he noticed. Like if it's subject to all the money, and, or is it just like
We normally start on time. Is this at what, 10 or 11? I think that was 7.
Yeah.
He was just he was feeling terrible. Something, yeah, cold related. Yeah, like yeah, yeah. I felt kind of bad because they had some Scientology thing going on.
Call this committee on Judiciary, Civil and Criminal Jurisprudence order. And getting started, we'll begin with roll call. Eric, can you call the roll, please?
Senators Dixon here, Under, Emery, Schaefer, Schmidt, Keeling here, and Stephen here. Your report.
All right, just a few housekeeping things. First of all, as a reminder, Missouri Chamber of Commerce, as well as Progress Missouri, have been granted permission to record audio and video of today's hearing. And additionally, in light of the number of bills, initial testimony today, I'm going to limit it to 2 minutes rather than 3. And I would ask the committee members, as you ask questions, please keep in mind the amount of time that we have available today does not match the number of bills. And I want to get through everything with breaking it up. So with that, I would entertain a motion to go into executive session. It's been moved and seconded. Those in favor say aye. Any opposed? No. We are now in executive session. I will entertain a motion on Senate Bill 17. This was the bill that changed intersectional, that's what it's going to be a good day. Intersectional references reflecting court costs. Okay, we will take any discussion on Senate Bill 17. Senate Bill 17, I think it was moved by Senator Kennedy, and who made the second? Okay. Any discussion? It just made minimal changes related to court costs, and it was only the intersectional references in statute that needed to be updated. Yeah. I don't think there was anybody who could testify. Okay, we will call the roll on Senate Bill 17.
Senators Dixon,
Aye.
Under, Emery, Schaefer, Schmidt, Keeling, Stephen. 6-0.
Okay. Senate Committee, 6-0, that is due pass. Senate Committee substitute for Senate Bill 81 authorized additional circuit judges for certain circuits when indicated by an annual judicial performance report. You notice I'm reading very slowly now. Senate Bill 81, Senate Committee substitute, I'll entertain a motion on that. Seconded by Senator Onder, seconded by Senator Kennedy. Is there any discussion? Senator,
I think the only substitute that just makes a substitute appropriation.
let's see, it includes language of Senate Bill 439, which was sponsored by Senator LeVota. It's an administrative change for the 16th Judicial Circuit requested by the Court of Law. So I guess we need a motion to adopt the substitute as well. It's moved by Senator Onder, seconded by Senator Kennedy. Discussion on the substitute adoption.
It has to be in the judicial performance report for like 2 or 3 years.
One second. On the substitute. Senator, would you repeat your question on the substitute?
All right, I don't know if the substitute on the original bill indicated that there had to be a need for 2 or 3 years on the review of the 3 consecutive years, okay. Okay, I'm good.
Okay, any other discussion on the substitute? Okay, moved and seconded. Those in favor of adopting the substitute, say aye. Aye. Any opposed, say no. You adopted the substitute. I'll now need a due pass motion on that substitute. Moved by Senator Onder, seconded by Senator Kennedy. Any discussion? Call roll.
Senators Dixon.
Aye.
Onder.
Aye.
Emery. Schaefer. Schmidt.
Aye.
Keegan.
Aye.
Zipper.
Aye.
6-1, or 6.
6-0 to due pass. Senate Committee substitute for Senate Bill 81. Senate Committee substitute for Senate Bill 91 would modify laws relating to public defenders. Need a due pass motion on the underlying Senate Bill. Moved by Senator Onder, seconded by Senator Kennedy. And a substitute, we'll need a adoption motion on that. It was distributed before the hearing of the witnesses that testified about conditions. That was appointment authority of the director and the legal defense and defender funds. Moved by Senator Emery, seconded by Senator Kennedy. Any discussion on the adoption of that substitute? Senator.
On the substitute, page 8, where we're not sweeping the funds anymore. I think that's what we said, we were not sweeping the funds because their funds came in erratically, and sweeping them was filling them every year. We're going to sweep down to 150,000.
Yes.
I was concerned that if there's, all we did here, we didn't put them in the limit, we just said they won't be swept anymore. I don't know whether that continues to build, but I know there were cases in there where they were up over $1 million. I wouldn't want to get in one of the circumstances that just continue to accumulate funds. But it also says that they're funded annually by appropriation. I'm not sure I completely understand that. We're still waiting on an explanation whether that gives us whether in fact if the funds built up, it would be a problem because we would come back to appropriations and just adjust it. I mean, I'm fine if that's the case, but if it's not the case, I don't want to get in a situation. I want to all of a sudden we say, wow, how did we do this? There's no, you can't sweep anywhere, we got to pass a law and then sweep the funds. So we either put a $1 million, can't be swept below Indian, or we can do some amount where we can just make sure that they are subject to appropriations. And I don't know if we have anybody here to say that.
Well, I
would do that or not.
I would say I think this one we would probably need to try to resolve and certainly work on the floor.
If
He's got my commitment on that.
Okay.
Um,
We're still waiting on you, so we'll try to continue to pursue that. If it's something that needs to be addressed, we'll try to have something ready for us.
I see some folks in the audience that would be able to address it, but we don't have time right now, so but you have my word, we'll get that fixed before we go to the, okay. Any further discussion? Those in favor of adopting the substitute, say aye.
Aye.
Any opposed? You've adopted the substitute for Senate Bill 91. We need to pass a motion. Moved by Senator Arnold, seconded by Senator Kevin. Any discussion? Seeing none, we'll call the roll.
Senators Dixon,
Aye.
Conner, Emery, Schaefer, Schmidt, Keating, Sifton.
Aye.
6-0, you do pass Senate Committee substitute for Senate Bill 91. Senate Bill 200 would modify the provisions related to first-degree murder. Is there a do pass motion on that? Moved by Senator Arnold. Is there a second? I see Senator Emery looking through the bill. We're just looking for a second.
Second.
Okay. Okay, a discussion on this. This was the juvenile life without parole, just for everyone's clarification. The juvenile life without parole, bringing that in line with the Miller versus Alabama. Senator Sifton?
And again, for clarification, if I recall correctly, we were setting it at 50 if you were 17 or older than 16, and at 35 years if you were 16 and under. Is that right?
That's what this bill is. Any discussion? Okay, we'll call the roll.
Senators Dixon, Conner, Emery, Schmidt, Keating, Sifton.
Aye.
5-1, you do pass Senate Bill 200. Senate Bill 304 was Senator Kevin's bill. Senator Schaefer, would you like to? Okay. And it modifies that was, we heard last week when I was out at custodial applications. And since that's your bill, I would have to make a motion to pass it. Second, by Senator Under. Do you want to explain it?
Yeah, there was no testimony against the bill. And I was there was a part in the bill that said if a suspect could refuse to be interrogated, but if he did, they had to record the interrogation, and we're just taking that whole thing out. Or record the refusal of the interrogation. We're just taking that whole section out. Missouri's a one-party state; they can record wherever you want. So it was seemed redundant, so we just took it out. And that's the reason for the stop.
And I'll make a motion for the adoption of the substitute. Senator Under seconds. Senator Emery?
No, question for Senator Kevin.
Yes.
So you're telling me since everybody liked the bill, you're changing it?
Pretty much.
Any other discussion? Any of those in favor of adopting the substitute, say aye.
Aye.
Any opposed, say no. You've adopted the substitute. May you pass motion. Senator Under will second that. Any discussion? Seeing none, we'll call the roll.
Senators Dixon, Conner, Emery, Schaefer, Schmidt, Keating, Sifton.
Aye.
6-0.
6-0, you do pass Senate substitute for Senate Bill 304. Senate Bill 321, Senator Hageman, creates the offense of unlawful contact with a victim of a sexual offense. And entertain a do pass motion on that. Senator Under. And I'll get a second. Second, Senator Kevin. And the substitute would remove a provision creating the offense of unlawful contact with a victim of a sexual offense and adds provisions relating to orders of protection. Adoption motion on that substitute. Second by Senator Kevin. Is there any discussion on that adoption? Seeing none, those in favor say aye. Any opposed say no. You've adopted the substitute. We'll need a do pass motion on the substitute. Senator Under and by Senator Kevin is second. We will now any discussion. Seeing none, we'll call the roll.
Senators Dixon, Conner, Emery, Schaefer, Schmidt,
Keating.
Aye.
Stifford. Senate bills 199, 417, and 42 dealt with deadly force. And let's see. I guess before I make my remarks on the substitute, we'll bring it, we'll do the motions. Seconded by Senator Kelly. The substitute that I will offer, just for everyone who's here, I want to make it very clear that this is not the final version of this bill. I have rolled the numbers together in seniority order. It is not everything I think needs to be in there, nor my colleagues, but we do not want this bill to sit in committee over spring break, and we don't really have time to get into making the bill what it ought to be today. So we have taken out the probable cause one, and basically this is a very limited version of what we can do today. So with that, I would, I'll need a motion for the adoption of the substitute. So, moved by Senator Allen, seconded by Senator Kevney. Any discussion? I'll try to answer questions. Senator Smith.
I just want to share your sentiments, Mr. Chairman. The bill, I strongly agree this bill needs to advance, needs to get to the floor. In its current state, I am concerned that it meets the standard articulated in neither Graham Connor nor the earlier Tennessee v. Garner case. So I do think that it's going to need work on the floor, maybe a set of substitutes. We need to bring our use of force statute into compliance with the United States Supreme Court precedent. We do have more work to do on it. The bill is before the committee now, and my view is not to do that, but I think we need to continue the discussions.
Thank you, Senator. And incidentally, I'm still working through this report. I have the DOJ's report right here, and some of the things that I've read, I've commented in this room last week, in fact, on we were in local government, and some of the things that I realize these are have not been adjudicated and things like that, but these complaints are nature of disgusting, is putting it lightly. And so we are working on what could go into a substitute. There be some things that haven't even been proposed, but for our purposes today, I think that we keep things moving and to be able to work on it. And my staff will be working over break on this without any interruptions.
I agree. Thank you, Mr. Chairman.
Any discussion?
Yeah, I do. I think the bill deserves to be out on the floor. I have some concern though that on the probable cause versus reasonable belief, and where we're at now, that I don't know if this version, I think it's a very sensitive topic. Because on one hand, well, we're dealing with very serious issue. So
Yes.
I guess could you just walk through in the substitute the changes that are
The only changes are on page 2.
Page 2. There's a change regarding the officer, so he or she.
And that's the copy. So go ahead. I'll just, if you'll read through it, I'll.
Yeah, just this one.
Yeah, agree.
Necessary to effect the arrest, and was added, or prevent an escape from custody. And also reasonably believes that the person to be arrested, A, has committed or attempted to commit felony involving the infliction or threatened infliction of serious physical injury. I don't think that's controversial, right? I don't think there was any testimony in opposition to that, in the sense that we're trying to get away from just because it's a felony.
Right, that was one of the recommendations.
Right.
As I recall.
Okay. B, no changes. C, we otherwise endanger or inflict serious physical injury to the officer or another person. That seems to make sense. That's all I have to do. Then we get to 3, an officer. Okay, so reasonable belief is what is currently in statute.
We left that and did not, in this substitute, I did not include the additional words of probable cause. There are some reasons, and now this is relating to Grand Connor, Grand Beacon, the objective reasonableness and my discussions with both of the colleagues at bill numbers. Those are discussions that we will continue to have, whether they relate to jury instructions or to the cases and that sort of thing.
Yes, some of the folks that expressed some concern, or different versions of that, where do they at on this?
I just met with them both this morning and explained what I just said here today, and they understand if we want to get it out. They don't like it, but they do understand.
Are you talking about the sponsors, or are you talking about the?
Yes.
Okay.
Yes.
And as far as some of the law enforcement folks that testified on the bill, there seemed to be an issue of reasonable belief versus probable cause. And going with probable cause, determined if they were supported probable cause or did not support probable cause. Did not support probable cause, with the deviation where we're at. Or is that accurate?
Yeah, that's right. It was not, I mistakenly thought that was in my original introduced version, and I did not have probable cause in my original introduced version. I see the argument. But
Okay, so this version does not change the standard at all, essentially, for the decision of the police officer, in the sense of reasonable belief is the current law.
we keep that, we get rid of the changes on the plain felon, which I think is really one of the major issues. It can't just be any felon, because it would have them taking advantage of this or that. It needs to be one where it's. So,
And in that regard, the bill does do something to align us to the Garner case. It just doesn't articulate the precise language used in Garner.
And so, may I?
Yeah, absolutely.
And so your concern is that it doesn't fully align with, is that your issue? That it makes a step towards, but does not go far enough, is that your issue?
Well, it is an issue. I mean, Garner says probable cause to believe. Grand v. Connor says objectively reasonable. Our statute and this bill say neither of those things.
Right.
And how we address that, I don't think we're going to get figured out today sitting here.
Yeah.
But we at least have, we have at least added that the felon has to be inflicting or threatening to inflict serious physical harm, which is something that I believe Garner requires and that our law currently does not.
Okay, thank you. Thanks.
thank you, both of you. Any additional discussion? Yeah, we'll, those in favor of adopting the substitute, then say aye. Aye. Any opposed, say no. If adopted the substitute, we'll need a repass motion. Moved by Senator Onder, seconded by Senator Kevney. Any discussion? We will call the roll.
Senators Dixon. Aye. Anders. Aye. Emery. Aye. Schaefer. Schmidt.
Aye.
Keating.
Aye.
Sifton.
Aye.
6-0, we do pass Senate Committee Substitute for Senate Bills 199, 417, and 42. Senate Bills 112, 143, 212, and 234. Sponsored by myself, Senator Romine, Walsh, and Kehoe, with modified provisions dealing with criminal offenses to align with changes made in the 2014 Criminal Code revision. Oh, okay, we have a mechanical issue. We're not going to do that one today because we have a. Okay, we'll have another executive session at the end because we need to hear 212 this case. Committee hearing first before we vote. I'm over. What about this last one? All right, we'll entertain a motion to go out of executive session. Second, those in favor say aye. Aye. Opposed, say no. We're out of executive session. Now, we will begin the hearing on, Senator Walsh is here. We will begin with Senate Bill 212. Senator.
Senator, I'm good with the previous agenda. Mr. Chairman, members of the committee, for the record, I'm Senator Gene Walsh from the 13th District. Here today to present for your consideration Senate Bill 212. This act adds the act of knowingly accessing or attempting to access the address of a participant of the address confidentiality program administered by the Secretary of State to the elements of aggravated stalking. Beginning in 2017, as a result of Senate Bill 491, which was passed in 2014, aggravated stalking will be known as stalking in first degree. This act also adds the act of knowingly accessing or attempting to access the address of a participant of the address confidentiality program to the elements of first degree stalking. The act is similar to Senate Bill 710, which strengthened Missouri's address confidentiality program due to the work that you did last year in the criminal code. 710 did not advance last year. The bill would expand the set of aggravating factors in existing stalking laws to include access the address of a participant in the Safe at Home program. Violators would be subject to a Class B felony resulting in a 30 years imprisonment. With that explanation, I would be willing to take any questions, and I do have testimony here from an organization that wasn't able to be desk, and I believe that there is somebody here from the Secretary of State's office.
Thank you. Any questions for Senator Walsh? Seeing none. Those in favor would like to vote. Those who would like to testify in favor, please come forward this time. Secretary of State's office, good to see you, sir.
John Scott from the Secretary of State's office. We administer the address confidentiality program. We think this is a great way to help those participants, and we're supportive of the information. Thanks.
Any questions? Thanks, John. Anyone else to testify in support?
I'm Amy Fight. I'm the Christian County prosecuting attorney, and I'm here on behalf of the Missouri Association of Prosecuting Attorneys. We're just here to say that we certainly are in support of the concept, and we think it makes sense. We certainly do believe that there may be some formatting and template issues that we have discussed with regards to making it comply with the criminal code revision that we are here to add.
Thank you. Any questions? Very much. Anyone else to testify in support? Anyone to testify in opposition? Seeing none, that will close the hearing on Senate Bill 212. And now that we've had that hearing, I think what I'll do is just entertain a motion to go back into executive session. Moved by Senator Onder. And a second. Senator Emery. Those in favor say aye. Aye. Any opposed, no. We are in executive session. And now I will entertain a motion on Senate Bills 112, 143, 212, and 234. Moved by Senator Onder, seconded by Senator Emery, and we'll need to adopt a substitute, which will roll those together and maybe other clarifications. Adopt the substitute by Senator Onder, seconded by Senator Emery. Any discussion? Those in favor say aye. Aye. Any opposed say no. We've adopted the substitute. And now we need to pass motion from Senator Onder, seconded by Senator Emery. Any discussion? We will call roll.
Senators Dixon.
Aye.
Onder.
Aye.
Emery. Aye. Schaefer. Schmidt. Aye. Keating. And Innocent. 4-0.
4-0, you have two passes. Case subject to Senate Bill 112, 143, 212, and 234. Senator, when the minority leader gets back, let him know that you presented the bill and had voted out before he even got back to it.
I'll do it, Senator.
All right. We will go out of executive session and to our hearing. And I'm going to find it again. So we'll go to Senate Bill 30, Senator Cunningham.
Mr. Chairman, members, thank you. Mike Cunningham, 33rd Senate Parole District. Senate Bill 30 puts more teeth in supplying intoxicated liquor to minors. It doesn't change the initial offense. It does change the second time you're caught and makes it a Class C felony. The final part of the bill says if you supply the minor and someone is injured or killed, thou shalt be charged with a Class B, which carries a 5 to 15 year penalty. And that's the main substance of the bill. The bill does not affect retailers, it does not affect anyone other than the person actually buying the alcohol. We've had a number of cases where this happened. I tried something like 8 or 10 years ago in the House, was not successful getting it passed. Hope for better results this year. So it does change. The first time it's just a Class C felony under the new criminal code, a small change. Twice the Class C, and the third time with death or injury would be to Class B. I'd be glad to take any questions.
As we discussed in my practice center, I know with the provisions, I was hesitant to do anything with criminal statutes this year, but I felt like after our discussion, this was something that the committee at least needed to hear and have a discussion on, so I appreciate you bringing it.
Yeah, it does, and I talked to a number of sheriffs and law enforcement people. It is a problem. I talked to some parents and grandparents who lost children due to this, and so I think it is something that we really need to take seriously.
Any questions for Senator?
Thank you, Mr. Chairman. So, Senator, did you get this from other states that are doing this? How do we move from where we are to here, idea-wise? Is this something?
Mike Cunningham drew this up.
This is something that you just thought would have to be.
No, I did not confer with other states.
You don't know if other states
I know
are addressed like this.
I know it's an issue. I had someone that said something in New York where the same thing happened. And
So the idea just is increase the penalty as the penalties that are incurred so forth.
And apparently that dealt with us. And I don't want, I mean, it's been a while, but back as a kid, we knew the local wino that was not get sent back over here or something. That's not my objective. But if it kills somebody or they're permanently disabled for the rest of their life, I think there needs to be more than a misdemeanor penalty for that. And it's currently what it is. And if there's no misdemeanor, in both cases, after this happened, 2 cases on one in Webster County, one in Ripley County, the person supplying just shared no blame for it whatsoever, and seemed to show no guilt in doing so.
Thank you.
Any other questions? Is there anyone in the audience that would like to testify?
Mr. Chairman, I have 4 witnesses. The first witness drove up from Ripley County. I appreciate it's quite a testimony.
Let's
I
have the
appreciate
first.
if you can wait a little bit on the time. The next 3 will be expert witnesses. And thereafter their testimony will be short. Mrs. Elliott will come up and appreciate it.
Appreciate you coming and your drive up here. Try to give you a little bit more time, but keep it as brief as you can. That would be helpful. Sweet.
It's quite a story. Made right there in 2014 was the last day of school for my child and several others in Ripley County. He went out with friends that evening and ended up in town until approximately 9 p.m. playing basketball, while one of his buddies had went with his mother's boyfriend to a local convenience store to buy a 30-pack of beer, to have fuel put in his vehicle, rode around with other children and his adult, and back in, picked up another adult, bought more alcohol, went to the park, picked up other children, started which was one of them was my son, also Alan Elliott, my only child. They drove county roads that nobody should drive on drunk. They're very dangerous. This driver was 16 years old. He turned 16 September 17th, 2014, or 2013, excuse me. The kids were in the vehicle for less than an hour. They drove around back roads or where they shouldn't have been, out and indulged in a lot of alcohol. My son passed my house 9 months before he was killed. We tried calling his mother. They fought to get out. All of this is on the reenactment statement from the other children that lived. I got a phone call at a little after 10:30 that there had been a horrible accident on 160 and wanted to know if we were home because that's where I live at. And that moment, something just didn't set right. And I couldn't get hold of my son. And that was odd. I got in my vehicle, got 4 miles up the road, and seen the vehicle of a friend of his on the side, crushed into a man and was out of it before I don't even remember stopping it. I got to the side of the road, and there was children everywhere, glass, blood, liquor. I seen a child laying on a stretcher with dark hair, with a white and gray shirt that looked like the shirt that my son had on earlier. The driver and my son had similar features, dark hair, darker complected. I got up this child and looked down and realized that it wasn't my Austin. And went to screaming and searching. And to the left of me, and I can still remember all of this so vividly, was my son partially covered. I knew he was gone, but I didn't want to accept that. I remember bits and pieces, and then reading the parts of the reenactment, and then talking to James Wilson and Sergeant Wheaton that worked the wreck to tell me what went on. I am in that reenactment, as noted by next again. They told me at the scene, the driver had been arrested and handcuffed to the stretcher for suspicion of driving under the influence. They told me that Austin was gone, even though I knew that he was gone in the back of my mind. Part of me did not want to accept that. I'm bothered to my heart. I just wanted to hold you. When my son was taken, I got a life sentence. The driver could have got a 15 to a 20 to a 30-year sentence for manslaughter and injury to the other children. But the 2 adults that went and bought this liquor for this child, our prosecutors, our law enforcement, they scrambled to come up with what they could to prosecute these men. One of the men, 30 days after this, was driving half naked down the highway watching young kids and got another DWI. The other one has been on going probation since he was in his teens. Has been up in front of the parole board 13 times for violating it. The last time that he was up, he was ordered not to be around anyone under the age of 21, to go into anywhere and buy alcohol, to consume it, or even where it was sold. 2 weeks later, he's in a truck load of teenagers again, going in trying to buy a 5th of Crown Royal. So yes, this bill is very important for me because of the loss of my child, but not just for my child, but for so many others before him and that will be after him. I get a sentence for life. They get a sentence maybe 1 to 3 years. They got child endangerment, supplying a minor with alcohol, which is a misdemeanor. I can go out and write a $500 bad check and get a felony, but they can go and kill and get a misdemeanor. And yes, when you ask about certain states that were following laws, I have studied them. Look at Ohio's. There's a lot of different states that have a lot stricter penalties. Alcohol-related deaths is more prone in people under the age of 20 from Thursday to early Sunday morning. 890,000 people drive drunk a day. Every 52 seconds, somebody is killed. 27% of that is our youth.
And thank you so much for taking the time to come up. My heart goes out to you. So sorry that you lost. I really appreciate you sharing that story and being able to do it. I'm sure it's extremely difficult to even tell the story. It causes me to remember a similar situation that unfolded in Springfield. You may be aware of it. This has met during project graduation. Senator, I thank you for bringing this to today. Thank you very much. Are there any questions for the witness? Thank you very much.
I have a couple others that you share that testify.
Would you like to tell me what order?
That was just called one.
Okay. Anyone else to testify in favor of Senate Bill 31? Senate Bill 30, excuse me.
Chairman, committee members, my name is Darren Reed. I'm Sheriff of Ozark County. I wholeheartedly support this Senate Bill 30. Changes make consequences more severe, enough to substantial incentive to prevent adults from providing alcohol to minors. Our young people do not have the ability to drink responsibly and without hurting themselves or others. Any jurisdiction across this state has suffered from fatalities involving people supplying alcohol to minors. So I wholeheartedly support it.
Any questions for this witness, Senator Emory?
Sheriff, can you think of specific, and I know I asked you to list them, specific incidents where you've encountered this kind of behavior multiple times, where this would actually help to put somebody behind bars or do something else to get them out of the way of these young people?
Yes, sir. We have just finished a case where a minor had been, alcohol had been purchased for him on several occasions. And there on the southern side of my county, this happened again, and this vehicle rolled, killing a 16-year-old boy. And I've done this job for over 30 years, and I can sit here and talk to you all day long about the effects of minors and alcohol and the ones that are supplying. The penalties are not severe enough for these violators. And I think we need to address these repeated offenders.
So you definitely would confirm that prosecutors would have a tool with this, that you as a sheriff would have a tool that you could actually use this law and you could keep some of those incidents from repeating?
I think it'd be a very valuable tool to the prosecutors and to law enforcement across the state of Missouri.
Thank you.
Thank you.
Any other questions? Thank you.
Thank you.
Sheriff, for being here. Anyone else to testify in support of Senate Bill 30? Welcome.
Mr. Chairman, Douglas County Sheriff Christy Gates, and I'm in support of the Senate bill as well. Recently, we've had some issues with a gentleman in our jurisdiction that's been providing alcohol to minors. We have cited him for the misdemeanor offenses that's gone to court. Many times in these cases it goes to court, there's not a lot that happens. They may pay a fine. The first time that we charged him with supplying alcohol to a minor, he provided alcohol to 3 young men who went out and then proceeded to go around the county roads and bash mailboxes to about 30. There were 30 mailboxes bashed. throughout the county. So he was cited for providing alcohol to the minors. The second offense that we had with him, he provided alcohol to a minor that was at a party that was attended by numerous high school students. And one of the boys had to be sent to the hospital. He did live, but he did have some alcohol poisoning. So this is an issue. I think the way the bill is written, that it covers not only the driving situations, but also in supplying it and with the alcohol poisoning situations as well.
Sir, it's just along the same line, Sheriff, because you mentioned that specific incident. Section 3 says penalty where there's injury or death is a Class B felony. So you believe you could have charged him with a Class B felony because of the alcohol poisoning?
Yes, well, the way that I read that, we could have charged him. So many of our laws that deal with distribution of drugs and alcohol, I mean, I think we're behind in the consequences being matching a crime. And I think this is one of those examples as well. Right now it's a misdemeanor offense, it'll be a slap on the wrist, nothing would happen to him. As a law enforcement officer that represents the people in my community, I have to answer to these folks. We have to answer to these parents when their children are deceased or when they're being taken to the hospital because they have alcohol poisoning. They expect us to do our jobs and they expect results from that.
How many arrests like that do you think you have to make before the word got out?
We're a small community. We're a rural part of the county, Douglas County, Southern Missouri. Very few. I mean, I think I do a radio program every week. I think if this were passed and it gets out to the community and we ran in our paper, I think that it would open up the eyes of the people that are supplying alcohol to our minors, and maybe they'll have to make any.
Thank you.
Thank you.
Any other questions for the sheriff? Thank you very much. And just as a general reminder, every witness needs to fill out a witness form and just leave it at the witness stand there if you would. Anyone else to testify in support of Senator Curry? Anyone else in support? Anyone to testify in opposition? Okay, seeing none, I'll close the hearing on Senate Bill 30. And Senator, you want to proceed to Senate Bill 31?
Mr. Chairman, I want to thank you for having all these bills together someday to save my witness from driving up here so time. That's very much appreciated. Senate Bill 31 has two parts, and the first part makes it legal to consume a Schedule 1 through Schedule 5 drug substance absorbed into the body. And I didn't have the idea, so I checked on this in my sheriffs, that consumption of a drug is not illegal. It's illegal to consume alcohol. You try for the FBI, but there's nothing, and I guess some drug people carry certain drugs in their mouth the way they get swallowed. There's nothing wrong with that. So if the sheriff catches somebody high, there's really no law against them consuming that. Once it's consumed inside their body, after they catch them with paraphernalia, other things, yes, they can go into custody. But if it's in their body, there's really nothing wrong. I was just amazed when they were finding it out. So this deals with that. The second part of it, on page 35, changes one word from may to shall when it comes to the revoking parole or probation. And this has been quite an issue in our area. We have this parole and etc. like that. Brought this bill forward. I think when there's something we have an instance, if you get caught and then the parole is not revoked, and I think the chairman, this may have something to do with shooting a police officer in Springfield recently in the last 30, 45 days. I think he's been caught, I don't know how many times, but his parole was never revoked, and then shooting his policeman. But we find several cases, and one of the witnesses will tell you about one in particular, but I found this to be true in other cases, where if it's not revoked, those people are free, and as long as they can stay out of jail, they can continue to commit crimes with no real consequences. Now, there is a fiscal note on this bill, about $1 million. I don't think that's real in that I think these people sooner or later are going to end up back in prison. And to leave them out apparently isn't working. I'm all for rehabilitation and stuff like that. But they've already proved they're not going to be rehabilitated. They're already out there committing crimes. And so we have an incident that Sheriff Reed will against pertaining to a young lady that will still be alive today. That is not
Good.
Be glad to answer any questions.
Any questions for Senator Cunningham? You want to have Sheriff Reed come up first?
I would. I have a prosecutor too. He's one of his.
Okay.
I have several witnesses. Thank you.
Come on up.
Excuse me, Prosecutor Mr. Klein is with us today from Ozark County.
Okay.
Mr. Chairman, member of the committee, with Senator LeVota, prosecuting attorney of Ozark County in my 21st year of doing this. Approximately a year and a half ago, we noticed a change in probation officer regarding felonies being committed by parolees and probationers. And to give an example of some of these, I will tell you of some of these circumstances. I will not identify the defendant or the parolee because of pretrial investigation. Number one would be parolee JM. Guilty of felonies of second-degree burglary and stealing in January of 2011, was placed on probation, received 120-day institutional drug treatment as part of his probation. In May 2011, he committed 2 felonies of unlawful use of weapon. He was subsequently sentenced to 3 4-year terms in the Department of Corrections. At some point, he was released on parole, returned to Ozark County. While he was on parole, I charged him with 2 new counts of receiving stolen property. In spite of this, he was left out on parole. While he was pending trial on new charges, he doped up on meth, he wrecked his car, he killed a 12-year-old child, and injured her 13-year-old friend surviving in the car. Parolee JH. This parolee was sent to the Department of Corrections in January of 2012. For first-degree property damage, he cut off his electronic monitoring while he was wearing that as a condition of his bond on another felony. In June 2014, while he was on parole back in the county, he was charged with Class B felony, burglary in the first degree as a persistent offender, and assault. He's still out on parole, waiting trial on these new charges. Parolee SF. He pleaded guilty to stealing a motor vehicle in February 2013, and was placed on probation. While on probation, he was charged in a different county with attempted robbery and armed criminal action. He revoked his probation and sent to the Department of Corrections for a 3-year term in our felony. He was released on parole in December 2014. He was stopped by a member of the Missouri State Highway Patrol. He was in possession of methamphetamine, drug paraphernalia, and marijuana. The trooper called me and I was out of state, and I told him to call probation for only a parole warrant until I could get back to my office and get him charged. The trooper called me back shortly and said the parole officer advised him that it did not meet the criteria to issue a warrant to place this person back in jail. Parolee JP. This parolee was a burglar and thief. He'd been involved in multi-jurisdictional series of crimes. And from our county, Ozark County, we gave him 4 4-year concurrent sentences to the Department of Corrections. He was released on parole at some point and then returned to Ozark County. In February of this year, while on parole, he engaged in another crime spree, burglarizing a school in Ozark County, a business. He also burglarized a school in Taney County and went to Douglas County and burglarized there. He was caught in possession of stolen goods and confessed. Probation office was contacted by law enforcement and yes, it did not meet the criteria to issue a warrant. I had filed a complaint with the state supervisor and they subsequently did issue a tank on him, so he doesn't want now.
I hesitate to move on, but is that something that you could provide us a copy of?
Sure. I'll be clean it up. I've got names of people.
Yes, certainly. I know everyone will be very interested, but for time, I'll put some questions, if there are any questions for the witness. Okay. Yeah, if you'll go and modify that and email it to my office, we'll get you the contact information, and we'll get it to the Thank you very much. Anyone else want to testify in support of Senate Bill 31? There's the sheriff.
Yeah. I'll make this very brief. I know your time is limited. This bill is very, very dear to me, and it has to do with probation and parole. And I'll give you one example of many, but just this last fall, I've been trying to put a parolee back in jail for several weeks who had been more crimes inside of the county, and I called probation and parole. I could not get a probation violation warrant. It was obvious this gentleman was using methamphetamines, also hydrocodone, and he used it on a regular basis. Matter of fact, his mother and father was supplying him. A very, very good young lady in our community got a ride with her girlfriend, whose mother is dating this parolee. And approximately half a mile from the house, driving at a high rate of speed, went off about a 100-foot embankment, killing the 12-year-old girl instantly. And until you've had a mother on scene beating your chest, screaming at the top of your lungs, you have no idea what that's like. I feel sorry for this lady that testified earlier today, because I can tell you, I know what that is like. And we're going to have to do something with probation and parole, or there's going to be more and more and more stories like this. As far as the second part of this bill with being consumption of methamphetamines or any illegal drugs, it's a joke inside of my department. These parolees come from drug court, come up to my office to do a urinalysis test, and they'll tell you right immediately, I'm dirty, there's no use wasting their time, knowing there's going to be zero consequences with it until after they violated this at least 10 times. And this is what we're facing at the Sheriff's Department. And whenever they do send them off, I just found this out just here a while back. A parolee only serves 15% of their time. So you can do the math. If someone sends off to the penitentiary for 4 years, they're going to serve 15% of it. They're going to meet me back home from the penitentiary.
Any questions, Coach Sheriff? Thank you very much.
Thank you for your time.
Anyone else to testify in support? Again, we want to make sure we've got 5 expungement bills, so I want to make sure that's okay.
I apologize. I won't be repeating what they said. Looking through the opposition to this, it comes down to money. That's what you're talking about, is money. And it's my opinion that this problem has grown. It's become such a big problem that some folks want to ignore the problem in order to fix it. And, I don't think you all would, I think y'all would agree with it. There's no price that can be placed on the people for safety in our communities. And these folks that have gone to prison or out on parole or on probation, they sign a piece of paper that says they will follow these rules. And all we're asking is that the word shall be put in there when they break these rules, because that's what's being asked of them. That's why they're not in prison. That's why they're not set in my jail, because they've agreed to these rules. And if the word shall is placed in there, it makes it mandatory that they would issue a warrant for these offenders. We in the small department cannot afford to keep appealing these people over and over. I said earlier, I believe there's crimes that the punishment doesn't fit. This is definitely one of them, because they are no fear of them going back to prison on this.
Okay. Any questions for the Sheriff? Thank you very much. Anyone else to testify in support?
Mr. Chairman, members of the committee, Cunningham, Director of the Missouri Sheriff's Association, I'd just like to go on record in support. This is not a localized issue. We received the concern from several sheriffs around the state that this continues to go on, seems to be wrong.
Any questions? Thank you. Anyone else to testify in the affirmative, Senator 31? Anyone to testify in opposition? Welcome.
Thank you, Mr. Chair, members of the committee. Sarah Roski with the ACLU of Missouri. Very briefly, the ACLU is opposed to any increased criminal restrictions for drug use. We think the drug use addiction are a mental health issue and a public health issue, and should be addressed that way by funding mental health services, addiction services, and actual rehabilitation instead of putting people in prison. When it comes to probation and parole, we're not really talking about, I understand the need to put people, or consequences for people who violate their probation and parole in a very heinous way, like the performance we're discussing. But there are a lot of probation and parole violations that need to be left up to the discretion of the officers to decide whether or not that person should go back to jail. Some studies show that almost 71% of the prison population in America is actually in prison because of probation and parole violations, not because of their original crime. And about 43% of those are for technical violations. When I'm talking about technical violations, I'm talking about crossing a state line, which if you live in Kansas City or St. Louis, is pretty easy to do on accident. Changing your residency and not giving your probation or parole officer timely notice, changing your employment and not giving them timely notice, associating with anyone who has a misdemeanor or felony, which is just really hard not to do. A lot of people have family members and friends and loved ones who have a misdemeanor violation or felony violation. And if they associate with them, that's violating their parole. And there are a lot of other special conditions that you can place on somebody when they're convicted of a crime. Of those 43%, that means for Missouri that almost 15,265 people are in prison currently in Missouri because of a probation or parole violation. People should be given as many chances as they can, especially when they've only violated a condition that has no consequences on anybody else's life but their own. If they forgot to tell somebody about a new job, forgot to tell somebody about a new apartment, crossed over state line in Kansas City and ended up in Kansas, they shouldn't be going back to prison for that. So requiring a warrant issue for any probation and parole violation is too much. It needs to be tailored, it needs to be cut back a little bit. That's all I have. Thank you.
Is there any questions for the witness? Thank you very much. Is there anyone else that would like to testify in opposition? Third. Oh, I'm sorry. Anyone else to testify in opposition?
It's a long day. I'm Jeff Stack with the Missouri Fellowship of Reconciliation. We feel similarly as ACLU. We recognize the problems that would happen to people who may be held accountable for violent crimes, but I think crimes previous in prison for some of these offenses it is going overboard, but we appreciate the intent of the sponsor.
Any questions for this witness? Thank you very much. Anyone else to testify in opposition? Okay. I understand that Ellis McSwain is here for this. Sorry. 22. I had some questions regarding the fiscal note for. That's quite all right. Just for informational testimony, I appreciate you coming. On the fiscal note, I understand that, as I understand the current process, when an offender is arrested, a violation warrant, but not in all cases. Can you elaborate when a violation warrant is issued?
Senator, yes. Actually, yes, I can. Having here with me today also is Peggy McClure. She is our subject matter expert on anything relative to violation reports and warrants. And I deal with the board side more than anything else, and I have her here to answer that question for you.
Okay. You're welcome to pull it in a chair if you're
Thank you. I understood your question. When do we issue a violation warrant? We usually do that when it's high-risk behavior. That will be when we identify that an offender has absconded from supervision. They've committed a new felony offense. We have high-risk offenders such as sex offenders. They have supervision strategies that require them not to go near victims, schools, things like that, dangerous felons. So those are the types of cases when we issue a probation parole violation warrant.
Okay, that answers my next question as well. Do you know if the department has estimates on numbers of offenders that the bill could affect? Out of curiosity.
On that, right now, we looked at last year's total. If the bill were in place last year, for example, we had roughly around 49,000 violation reports that were issued. That 49,000, 15,000 those in the warrants. 8 on the probation and parole, 8 on the probation side, and 7 on the parole side. So that would leave an additional 30,000 violation reports that would have required a warrant if the bill were in effect saying shall.
Okay, do you have it? Any, sorry, I understand that, expected fiscal impact. Any comment on that?
Yeah, the fiscal note really relates to what we believe would be an increase in our population by a total of around 250 offenders annually. That's what the $1 million in the fiscal note relates to.
But what does that relate to as far as impact on the courts, not necessarily the fiscal side, but
The impact on the courts would be, the impact on the courts, I think we have some impact that we have on our operation on the probation control side. The biggest thing that I see with this entire bill, with all due respect to the sheriffs and the senator, who we work with down in that area, and we're trying to close our gaps on different sides, is the discretion issue. It would simply eliminate all aspects of discretion, because if there was a violence report that was issued, it would require a warrant and then be jailed, if it would be jailed. Our staff go through a variety of different supervision strategies to manage risk related to clients, offenders, and this would essentially eliminate that possibility. And I would imagine it would have the same impact on the courts and their discretion, keeping in mind the biggest part of our population are probationers, by more than 2/3. And our staff work with the courts in dealing with the clients who we don't place in jail. We manage supervision strategy to deal with their risk, whatever the issue might be at that time.
well, I appreciate your ability to come and willingness to come and answer some questions. Just quickly before we close out, the senator and I have visited about the issues in his area, and I've had separate discussions with some in the other chamber, the chair committees. It sounds to me like maybe we have some issues in that area that we're not experiencing elsewhere in the state. If I could just encourage the resolution of those so that, I'm perfectly willing to solve it this way if this is what it's going to take.
I can tell you, sir, to that end, we've gone down to the West Springs area to meet with the sheriff, the prosecutor, and others who've been senator in the past, and developed a good relationship with some of the sheriffs. We intend to continue to close those gaps that where we see the difference. We have cases where we have high-profile cases where there are bad cases, and we have those periodically. We go through every aspect of that case. Our staff, our executive staff, to review it for anything where a ball might have been dropped, so we may have been missed. It may require policy revision if we see that's the case, but we look at those cases very seriously. We deal on a case by case, and our entire executive staff and others that are subject matter experts review those cases. Any kind of infidelity where there may have been something that may not have added up.
Okay. I appreciate both of you. Thank you very much. Senator, thank you for both bills. Appreciate your time and willingness to have your constituents.
Mr. Chairman, you have some good legal minds up there, and it used to be where, either fence crossing the state line, unless they're in drug or something like that. It had to be ruled out of this, and some type of action taken. A 12-year-old goes to life longer than that, and you're a police officer in Springfield, you're not going to shot. I know it's a tough road. And once the warrant's issued, then it goes to the judge, I would present it, and then the judge would make a recommendation of whether or not they get treatment or whether or not they're free to go. And drugs dangerous, and it's some type of malicious either offense or drugs considered dangerous. Maybe the lawyers get on the staff, maybe with guidance and direction. Thank you.
Thank you, and again, Senator, my heart goes out to the constituent that visited with us today. Thank you. Okay, we will, that'll close the hearing on Senate Bill 31, and we will now, we're going to advance to, colleagues have a meeting that they need to get to, so we're going to advance to Senate Bill 165. Senator Sheed is here. And this will begin one of our 5 expungement bills. And Senator, it's up to you if you'd like to present, and then go to your meeting. We'll finish the hearing, or you can stay.
Thank you, Mr. Chairman and members of the committee. Good afternoon. For the record, I am Senator Jamil Nasheed, representing the 5th Senatorial District in the city of St. Louis. Today, I present to you for your consideration and support Senate Bill 165. Senate Bill 165 allows for certain individuals to file for expungement of certain criminal records. Senate Bill 165 allows those following offenses to be expunged: prostitution, drug possession offenses, criminal non-support, and traffic violations other than DWIs. Those are the ones that we're looking to expunge. The following offenses will not be eligible for expungement: DWIs, sexual offenses, endangering the welfare of a child, and felony committed by a commercial driver's license holder. Those will not be subject to expungement. Individuals will only be able to expunge their records after 5 years of walking a straight and narrow line. That's very important to note, that we're not saying that when a person commits a felony charge, the next year they can go get their records expunged. That's not what we're saying here. Even after the expungement, the relevant records may be available to all law enforcement. All law enforcement will still have the opportunity to look into the records of felons, all the felons that we're trying to expunge. And in case of any prosecution, the lawyers, they can look into those records as well. I've been working on this for 7 years now, okay? I started off with this particular piece of legislation 7 years ago, and that's when Illinois, they passed their first expungement bill in Illinois during the time that I started working on this one here. One story I need to tell is, we can go into the bill if you don't like. One story I need to tell is a young lady who found herself, she had lost her job, accounting, and she got into, she fell into the hard knocks of meth, okay? She started using meth, okay? And she got herself clean, but before doing so, she caught a felony charge for meth. And when she got herself clean, it was very, very difficult for her to go out and obtain a job so that she could put food on the table for her children. And for years, she was not able to get a job simply because she had a felony charge hanging over her head, okay? This is a story of millions throughout America, not just America, but in the city of St. Louis and throughout the state of Missouri. You have individuals that have made mistakes over the years. They have paid their debt to society. Many of them, they come out of prison, knock on the doors of opportunities, the doors are slammed in their faces each and every day because of the stigma of being an ex-felon. And what happens is, we become their jobs, because if they're not able to go out there and get a productive job to put food on the table for their children, they're going to turn to the life of crime. And so the recidivism rate steadily rises. And if at some point, we as legislators, we have to step up to the plate and begin to figure out how we can help a better society when it comes to those young men and women out there who've made mistakes in the past. Now, a source NBC, employees who have previously been incarcerated are 1 to 1.5 times more productive on jobs than those that have never been convicted of crime, because they have had the structural living, so to speak. I mean, they have to wake up one time, they have to go to sleep when the warden tells them to go to sleep. And so they come home and they are more productive in terms of being able to stay on those jobs because they have been in the structured environment. So again, that's what this bill is about. It's about expunging the criminal records of those that have paid their debt to society. It's a bill that I've been working on for 7 years. I have other colleagues that are working on the same piece of legislation. Again, this legislation will only deal with prostitution, drug offenses, and criminal non-support. Now, no criminal non-support is a piece of legislation that many of my colleagues have worked on in the past on the House side, and we've had obstacles trying to get that piece of legislation passed because of the federal connection and the funding that comes with that. So with that, I'll take any questions.
Any questions for the senator? Okay, seeing none. Why, Senator, if you don't mind, what I'd like to do is that you and Senator Curls can get to your meeting. Why don't we go ahead and have her present her bill, and I will leave both of those up, and then we'll have witnesses on those two bills at the same time. Would either senator object to that? Okay, because I know you both need to get to that meeting. So, Senator Earls, why don't you come up and present, and then you're both having that time has arrived. That way we can let you all get home to ready to go.
Thank you, Mr. Chairman. For the record, I am Senator Keaton Curls of the 9th District in Kansas City, and thank you all for allowing me to present Senate Bill 307. Mr. Chairman, Senate Bill 307 expands the law relative to expungement of criminal records. It would include any non-violent misdemeanor, felony, or municipal offenses. I want to repeat that they would be non-violent offenses. In that, they would not include those offenses that happen to include use or possession of a weapon. It would not include those offenses that have use or threat of physical force, injury, or death, and would not include those offenses requiring registration of the sex offender registry. The bill provides that a person must wait at least 10 years to petition the court for a felony conviction, and at least 5 years for a misdemeanor or municipal violation. I will say also, Mr. Chairman, that they would have had, for him to be able to petition to the court for the expungement, they would have had to have finished a sentence or imprisonment, they would have had to have finished their period of probation or parole, they would have to have paid any restitution ordered by the court, and could not have been found guilty of misdemeanor or felony during the time period specified for their offense. Mr. Chairman, I sincerely hope that this is something that this committee can give serious consideration to. As we know, and as the senator said earlier, many of these folks, years later, have paid their debts to society. They are trying to continue with very productive lives, and as long as they have been on the straight and narrow, I think at some point, Mr. Chairman, they deserve some relief and be allowed to continue their lives without the burden, of course, of offenses that may have been committed when they were teenagers. So with that, Mr. Chairman, I have to answer the question.
Both Senator Curls and Senator Sheep, thank you for bringing this forward. And just for point of information, what we're talking about here really is criminal code revision part 2, because this was a version of this was in the bar's recommendation for criminal code revision. And Senator Justice and I felt like, along with Senator Representative Thompson and Chris Kelly, were concerned that we needed to separate it out and get the other stuff done. And of course, also thank you. Any questions for either Senator Sheep or Curls? Okay. Senator,
Question for Senator Curls. Have you seen the fiscal note on your bill?
I have seen the fiscal note.
What? I haven't had a chance to review it.
Here's what I will say. That it says up to $103 million. Of course, that would provide that every person that has an offense would then, of course, petition to the court for expungement. I think many of us know that the likelihood of is very slim, the minimum. And the fiscal note, as I said, estimated net revenue is up to, because there's no way to be able to quantify right now how you would petition for subversion to be up to 103.
I don't know, and even if everyone does petition, we can't imagine it would cost $100 million.
That was.
Oh, positive, it would save money?
I will say that on the second, well, I will tell you that in the second section, it does say the fund effective criminal record, positive fiscal note, $26 million. And 16, 27 positive, 17, 28 positive, 18.
Okay, and that would be revenue from the fee.
Thank you, Senator Sheep.
I have a problem, I'm looking at my bill right now, I do have a problem that I think needs to be fixed in committee. And this bill doesn't really define how many times a person can go for an expungement. So that's something that I would like to talk to the committee about, any of the lawyers on the committee, to see, how feasible, how many times.
Limitation.
Yeah, what's the limitation process? Can you just, go get an expungement, and then you get in trouble again, and then you go back and get an expungement? That's not clarified in my language, so that's something that I want to talk to members of the committee about.
Thank you both, and if you need to run, I understand. We'll go ahead and open both Senate Bill 165 and 307 up for witnesses in support at this time. Thank you both for your patience.
Thank you.
Hello again, Senator Sarah Rossi with the ACLU of Missouri. I'll be brief. I think senators and sponsors said all I would ever say about these bills. If we want to reduce the state budget, if we want to stop spending money, we have to reduce mass incarceration. If you want to reduce mass incarceration, you have to reduce recidivism. If you want to reduce recidivism, you have to give people a chance to get jobs. Getting these records expunged will help a lot of people get jobs, it'll keep a lot of people employed, and it will reduce recidivism, reduce mass incarceration, and reduce the state budget. I think it's a win-win. We're going to get some money from those fees. So I'm full support. Thanks.
Thank you for your testimony. Anyone else in support, very quickly?
Brian Burns, County, Missouri Association of Criminal Defense Lawyers, with the law and record recording all these criminal bills.
Okay, if you want to just list them all on one form, that'd be great. Thank you. Anyone else to testify in support? Very quickly, again, we're running out of time. And it would be noted and appreciated if you just say me too, and your name and fill the form out.
Good afternoon, Senators. My name is Andrew Boyd. I just want to share with you, this is a picture of my daughter, and I was not able to attend her high school graduation. I was not able to attend her graduation from the United States Air Force. But I would want you all to know that labels do continue to punish, whether you want to use the word punish or not, well beyond the offense, including today, the punishment now carries over to families. Scowl that goes onto the face of the punished who has served their time, that permanent scowl, is now transcended to the family, to the children. They see this non-smile and they grow up not smiling. Their parents of the offender, they have a broken heart every night. So this broken heart, this pain that is no longer with me, but now with those who I love, who don't understand this and don't recognize where it's coming from or how they got it, now pass it on generation to generation to generation, never really knowing where my pain came from. But it does come out when they grow older. And what I want you to consider is, this is real pain. This is something that really needs to be considered. It's actually a mental issue right now. It's a disease.
Thank you very much. Any questions? Thank you. Anyone else? Senator?
If I may add, Mr. Chair, I know you said you're short on time, but there are about probably almost 25 folks here from laypersons and constituency that are here to testify as well, in addition to some of the other folks I believe here in the Capitol. So I'm not sure how you would want them to proceed. Are you just wanting them to fill out appearance forms? Or
Could I see, just for the
time?
committee's benefit, a show of hands of folks that would like to testify in support? Okay, thank you. If you are comfortable, and again, we have 3 other expungement bills, what I would ask just for the ability to hear all those bills, if you would have your form filled out, come up and lay it on the table, show us, just come up and say, I want to go on record in support of your name and where you're from. And we won't leave it at that unless you have something that really, really has to be said. That would, otherwise we're not going to get to everyone. Because we have to go back to the session and the room is going to be used at 3 o'clock. Okay. Welcome.
Thank you. Thank you for having me today. Can you hear me now?
If you'll speak right close to them, thank you.
Thank you for having me today. We kind of drove a long way to get here.
Thank you.
Because this is so passionate to us. My name is Bishop Tony R. Caldwell. With the Community Economic Justice Coalition out of Kansas City. Expungement means a lot to a lot of people. Keep punishing someone for the rest of their life is not a good thing. I think we all understand that to begin with. Even as myself being a young man, 19 years old, and got my felony, I'm still paying for it today in my 50s. There comes a time point that we need to move beyond, to start healing, but also be able to let those people become productive in society. A felony over their life, or the rest of their life, is not allowing them to be productive. It starts the rate going right back into prison. And I know we want to cut down that rate and cut down crime, not build it down. So please consider it.
Thank you.
My name is Freedom Benz. I'm also pastor of the Community Economic Justice Coalition. I'm just here to have
1770
Thank you very much.
Citadel Drive, apartment
Yes, sir.
111. That's 64110.
This is a no-brainer. I'm Oliver Harris from Kansas City. Life is hard sometimes, especially for some people. We're here on this earth to try to survive.
Yeah,
And survive in these
816-605-1142.
And sometimes people do the wrong thing. But when they do the wrong thing and they pay the price, I don't see how they have to pay for the rest of their life, keep on paying and paying. The person that goes, I've seen people go to prison and come out, and they come out knowing how to read, how to write. I have one guy just writing a novel now. And when I read it, I was just amazed at his ability to communicate. But then if he gets out of prison and goes to apply for a simple job or something, oh, I'm sorry, we can't use you. They just throw it in the trash and stuff like that. And that's wrong. So let's, if he's paid, done the time, let him out. Let them give them a chance. That's only fair. And it's hard to survive. And when you don't give them a chance, and they come out and you can't get a job after 2, 3, 4, 5 years, what do you think they're going to do? They're going to do more than they ever did before.
Thank you, sir. Welcome, sir.
Hello, I'm Kenneth Mosley. I'm here for support of Bill 307. 2001, I lost my youngest brother to crime in a shootout. One of my other young brothers now, he's a felon. His record, he's been clean for about 10 years now, and he's having difficulty finding employment. I want this to pass so that on a daily basis, I talk to him about the issue of getting employment. That this will make a big difference in his life, so he doesn't return to the lifestyle that's prevalent in his school.
Thank you, sir.
Yes. I'm Mrs. Esther Holzendorf. I'm with the Community Economic Justice Coalition. I'm also retired from the Oklahoma Department of Corrections, and I'm retired from the Jackson County Division of Family Services. So I've literally seen what happens to people from the cradle to the grave. Once a person is out of prison, they need to be able to get a job where they can make a livable wage, take care of themselves, take care of their family. You do the stats, if you talk to folks who work in corrections, you find that they're less likely to reoffend if they can find a good job and get paid. It's a benefit as far as economic growth is concerned. It's also very beneficial because instead of being a tax liability, they begin to pay taxes. So I think we really need to take a look in a real way at expungement, because they're already out. They've served their time. So now let's give them a chance to really keep their life on track and not go back to what got them in trouble in the first place. Because a lot of these crimes are drug-related offenses. So I would like you to really seriously consider the fact that we're spending like $22,000 a year keeping people locked up. And the recidivism rate, you know. So please just seriously take a look at this.
Thank you. Thank you very much. Yes, sir. Oh, Senator.
Really quickly. So with the remainder of the group, would you just prefer that they submit the witness form to move on to the?
Otherwise, we're not going to get to everyone.
Right, okay. So, is that okay? Okay.
Yeah, and just if you want to come up and leave your witness form at the table here, you should fill it out completely, or you can give it to the doorman, and we will make sure that you are entered into the official record as being a proponent of these two bills. If you wish to also go on record in support of the other three bills, you're welcome to list those bill numbers on the same form. Okay? Anyone else to testify? Yes, sir.
I just want to say what they have said, me too.
Thank you, sir. And please be sure to fill out a witness form. Thank you very much. I know a lot of folks go a long way. This is a very important issue. Yes, sir. We've not opened that hearing yet. Anyone else to testify in support of 165 and 307? I think we've addressed that with the witness forms. Anyone to testify in opposition to those two bills? Seeing none, that will close the hearing on Senate Bill 165 and Senate Bill 307. And I know that those two senators had that meeting, so we went out of order, and I want to go back now and get Senator Romine's bill. Thank you for your patience, Senator. Senator and a gentleman. Senate Bill 36.
Thank you, Mr. Chairman. Happy to accommodate colleagues. Thank you, Mr. Chairman, members of the committee. For the record, Senator Gary Romine, representing the 3rd Parole District, present to you Senate Bill 36. And I will give you the abridged version. This bill does 4 things. It takes the Commission on Human Rights Act from a contributing factor to a motivating factor. It changes the definition of an employer. It sets caps, damages, and then it also creates a whistleblower protection act. With that, I'd be happy to answer any questions.
Are there any questions for Senator Romine? Seeing none, do you have witnesses to testify in support?
I do have, and
Thank you, Mr. Chairman. General Counsel of the Chamber of Commerce and registered lobbyist. I think this bill is something most people on this committee have seen before. It's been urgent for a long time. Happy patience.
Any questions, Mr. Atkins? Seeing none? Oh, I'm sorry. Senator Stitt.
This bill on here for the question, there's some changes. Not to be flat, but is there anything new on the side that we have seen?
No, there's not.
Thank
you. Any questions? Thank you very much. Anyone else to testify in support of Senate Bill 36?
Mr. Chairman, David Overfeld, on behalf of Missouri Grocers Association and Missouri Retailers Association, we would like to go in favor of Senate Bill 36, and Ray is here.
Thank you very much. Mr. Carter, welcome. To testify in support of Senate Bill 36.
Yes. Oh, yes, he's been at the state. 2 years, 2 times. Ray McCartney, President of the Associated Industries in Missouri. We'll be on record in support of this legislation.
Any questions for Mr. McCartney? Wonderful. Thank you very much. Anyone else to testify in support of Senate Bill 36? Anyone else? Okay, seeing none. Anyone to testify in opposition to Senate Bill 36? Welcome, sir.
Mr. Chairman, committee members, my name is Eric Preble. I'm the Director of Investigative Operations for the Missouri Commission on Human Rights. The Commission on Human Rights is in opposition to Senate Bill 36 because